Welcome to the Crypto Lounge. I'm your host, Doc Vince, and today we're diving into the world of DAOs, Decentralized Autonomous Organizations. These innovative structures are revolutionizing governance and collaboration in the blockchain space. This episode is brought to you by ICORBP, or International Council of Registered Blockchain Professionals, the block committed to advancing the standards and knowledge of blockchain professionals worldwide. Joining me today is Vladislav Odiensky. He is a lawyer and expert in tech, blockchain, NFTs, AI, and fintech with extensive experience in legal compliance through Icon Partners. Vladislav will help us break down what DAOs are, how they function, and why they're becoming so significant in the space. Whether you're new to DAOs or looking to deepen your understanding, you're in the right place. Let's get started.
Yeah, so I'm actually is a postgraduate obtainer in the Ukrainian university. Actually, a decentralized autonomous organization is my scientific interest, and I'm writing a research on this subject. Of course, I'm a senior lawyer at Icon Partners. Actually, we provide legal services to Web3 companies, but we are not restricted by only Web3 companies. It is just an IT companies, fintech companies, and etc. But Web3 companies are companies of our special interest. So we are trying to be always in the subject, understand everything, and provide not only the practical solutions, but also the theoretical one, so we can better understand it. That is why I actually attended my university, and so will be a PhD in this theme.
Let's go ahead and talk about our topic for today, DAO. The rise of DAO represents a paradigm shift in how organizations are structured and governed. Given their decentralized nature, how do you see the legal framework evolving to accommodate DAO and the challenges that it might present for both creators and participants? And as DAO really grows popularity, they have several challenges. Traditional legal structures, which are often designed for centralized entities, these things that are really evolving the legal framework, will need to balance innovation with regulatory compliance. So the question is basically challenges, things, and the legal framework.
Yep. So the main problems is actually can be stressed out by the quote from UkiDAO case with the Commodity and Future Trading Commission, CFTC, in the US. So it says like the document that is published on their website, the document is dedicated to those who believe that they can circumvent the laws by adopting a DAO structure. It is not a negative or positive document, but it just says that even though you are a founder of innovative, technologically new company, organizations that has never been created before, you shall still comply to the regulations that have been created before, even though they are not adjusted very good to blockchain or Web3 world, but CFTC, Security and Exchange Commission, SEC, or any other regulator will still apply those regulations to you. So here we can answer the first question of current legal framework and concerns with which crypto projects face. It is the regulatory requirement to be complied with all the general laws. So it includes, first of all, of course, civil law, corporate law, security law, and any other laws that were existing before. So yeah, we may talk here a little bit more about what is DAO actually. Of course, DAOs is the decentralized autonomous organizations, which are it can be said that are governed by computer algorithm, and all the decisions are written into a blockchain. And here we can see the decentralization, since all the processes are managed by members of such companies, not by some centralized um, authority of major shareholders. And autonomous because idealistically, most of decisions shall be executed by the corporation itself. We may say that they are executed automatically, but simplifying, it is so. But actually, many scholars, they differentiate automated execution and autonomous organization. These features can be distinct. So talking about that, here we have the main feature of DAOs. It is an organization, which means that there are two or more members, which means that most of regulators, they will view such organization as one that is already existing in the legal frameworks. So these are either the general partnership, if we are talking about entityless DAOs, or it is a corporation, if the DAO has created some corporation. Therefore, the main problem here is that if DAO opts in to create the DAO as a corporation, it shall adjust its processes to the already existing rules, which is foreseen in, for example, civil codex, if we are talking about continental legal system, or corporate codexes. And it is very hard to actually use any blockchain technologies or automate your execution of decisions, because civil law is actually very simple in this case. You shall have the director that will execute your decisions, and everything shall be in writing. There shall be reports and etc. Moreover, if we are talking about the idealistic decentralized autonomous organization that was described by Vitalik Buterin in his works, DAO shall exist on blockchain, but all the corporations actually exist in registers. They are entered into register by regulators, and moreover, all the shareholders, members shall be counted there, and it actually conflicts with anonymity of those shareholders. So yeah, it is very hard to realize the full potential of decentralized autonomous organizations. That is why sometimes we may see the distinction between real DAOs and fake DAOs. Fake DAOs, they are strive to accommodate to those legal frameworks that already exist. Therefore, we have the following situation in different jurisdictions. It is not the regulators who try to accommodate to DAO, but rather DAOs that try to accommodate to the existing regulations. Examples here may be Wyoming LLC DAO, which is actually just an LLC with some adjustments for DAO, like using the blockchain or using tokens as something that gives voting rights. Plus, here we have example of Cayman Islands with their foundations. It's just general foundations, but startups, they can adjust in bylaws, for example, their managing procedures to use such foundations for DAOs. or even the recent Marshall Islands DAOs. We have the law for DAOs, but it is just LLC. It was created on LLC. So we can see such decentralized autonomous organizations as a superstructure that is built up on the already existing rules. And such superstructure can be used fully, entirely, uh, as it was intended before. Therefore, the main concerns with that is that it is the DAO that shall accommodate to legal frameworks, but not the legal frameworks shall accommodate to DAOs. And you can see this on those examples that I have mentioned, and in general by the positions of regulators. In my opinion, unless we reach algocracy, it is the government that is governed by algorithm. The idealistical DAO isn't feasible. So unless everything is governed in state by algorithm, unless it is possible to not use some registers but write everything on blockchain, we cannot realize the full potential of DAOs.
How do you see regulators in terms of adoption of the technology in your own um, perspective?
Yeah, they are not flexible at all. Since we can actually say that DAO has emerged very it has emerged even in 1990s. There were works that was dedicated to decentralized autonomous organizations, but actually it was more in terms of smart houses. So let's disregard it. Many says that Bitcoin was the first decentralized autonomous organization. Then there comes BitShare, but the real decentralized autonomous organization was created in 2016, the DAO that was hacked. But yeah, it is a negative experience, but it was the first decentralized autonomous organization. And from that point, from 2016 to the 2024, we may see that not all the jurisdictions have applied or have created the legal frameworks for decentralized autonomous organizations. We can even count it on our fingers. It is Wyoming, it is Cayman Islands, it is somehow British Virgin Islands. They say that DAO is possible there.
Mm.
Marshall Islands, Swiss foundations and associations, as there are some explanations how to structure that. And maybe there are other countries, but it is a very small amount of countries. They are not flexible in such idea at all.
Hmm. You did mention about token, and maybe we'll dig more on the legal implications of token distribution and governance, because tokens really play a crucial role in DAO governance. Am I right? But their distribution and use, and it raises a question about regulatory compliance, particularly with securities laws. Now, understanding these implications is really vital for DAO sustainability. Without understanding this, I don't know if DAO would ever push through. Maybe you could elaborate, and can you elaborate on the legal implications of these elements, particularly in the context of potential securities regulations?
Yeah. So here we come to another problem that the previous laws exist. So security laws were existing for a long time, and even DAO shall comply with all the regulations, even notwithstanding that they are very innovative, technological, and etc. And we can see it from the positions of SEC, CFTC, or even in European framework with their MiFID second and the recently adopted MiCAR. money in crypto regulation. Uh, so yeah, uh, the DAOs that want to solicit any public, they shall remember about such laws and shall comply with them because, for example, SEC, they say that they have the extraterritorial jurisdiction over any company. So if you are trying to sell your tokens to US citizen, uh, SEC can fine you. Uh, the same situation with European Union. So every country, for example, if you are targeting the German auditory, the BaFin can fine you. So even though you are creating the company for your DAO or not, so you are going with an entity or entityless, you still can be fined because, as I said, if you are going entityless, your DAO can be viewed as a general partnership. Furthermore, with general partnership, all the founders they will be fined as a full with a full liability because it is not restricted by entity. Uh, Furthermore, we may talk about different about different cases. It is a very important case and the most well known. It is the DAO order issued by Security and Exchange Commission, which says that the tokens, even not tokens, any cryptocurrency, uh, anything that is issued, for example, even NFTs, it may be viewed as securities
Correct.
because if such token it undergoes through Howey test and it is concluded that all the four features are met, then such a token will be, of course, recognized as a security. And the main characteristic here is actually do the members have a voting rights in DAO? But we shall distinct here voting rights because not all the voting rights actually actually state that you had any rights to govern the company. For example, just voting in some polls, for example, which color our banner shall be, or which footer shall we use, or something like that. Actually, it shall not constitute the government's right, since you are not defining the direction of developing of business. So we can distinct here also. Not all the voting rights are governance right. And of course, if the DAO it pays dividends, for example, to its members, most likely it will be recognized as security in most jurisdictions. But actually, if it is possible for DAO not to be recognized as for DAOs tokens not to be recognized as securities if it doesn't give to if it is only a utility token, if it doesn't give the right to earnings, to share profits of the company, and even if it gives rights to govern the company, it can be not a security since, for example, under the Howey test, the investor he shall expect the investment returns from such investment. But if the DAO is non-profit, then there is no profits, there is no dividends.
Correct.
And the same works with European markets, where there is a financial instruments, and we shall apply the same for those markets. But we shall remember that Howey test is not appeal for European market because there is other legal cases, other laws, and etc. So it is very important.
For the sake of our viewers, I'm going back on the distribution. Maybe you could lay it down as simple as possible. How is the token distribution in DAO?
Yeah. So here we shall remember that actually token distribution can be made in different ways. Of course, the initial coin offering, the initial exchange offering, the initial DEX offering applies here. So those tokens can be, for example, sold to the investors, or maybe even airdropped to the investors. Or maybe it is just like a private placement if we are talking about such tokens being recognized as investments. So yeah, everything such can be made by such ways. But anyway, notwithstanding the way you have chosen, you shall remember about the security regulations, because even airdrop under the SEC orders, it can be recognized as an investment, because
Mm,
most of airdrops, they require from the investor to make some actions, for example, to promote services or to make some tasks or etc. And it is viewed by SEC as an investment of time and etc.
Here's another thing that really is kind of strikes me the most regarding liability. Talking about liability in decentralized decision making, because DAOs distribute decision making across different participants, and complicating the assignment of liability. Understanding how responsibility is managed in this decentralized environment is key to addressing legal disputes. Now, in a DAO where decision making is decentralized, how does the concept of liability translate? Who bears the responsibility in the event of legal disputes or financial loss?
Yeah. So, as it was stated, we should remember that there are actually simplifying two types of DAOs. It is entityless and with some legal entity structure. So, if we are talking about entityless corporate organization, uh, most likely it will constitute a general partnership under laws of the most countries. And in such a case, the founders, or even not the founders but members, they may uh, they may share the full liability for all the debts or actions of DAO, because there is no organization that could have limited those liabilities. And we can see it, if I'm not mistaken, BZX protocol decision. So it was also versus CFTC
Mm.
commission. And yeah, it was stated, and many, actually there are plenty of court decisions that says that even though it is a DAO, but still the organization of several members of natural persons that share the same purpose, and they have united to reach that purpose, it will constitute the general partnership if they haven't created the some structure, the
Mm.
organization that could have limited such liability. So yeah, in such case, they will have the full liability for all the debts or actions of such DAO. But if we are talking about the organization that has chosen to be a legal entity, in such a case, it will be depending on which type of legal entity they choose. It will be the restricted liability, for example, limited liability of limited liability company.
Oh, I
Uh,
see.
that is why actually Wyoming has gone through this uh, way. They have created the wrapped DAO. It can be named like that, wrapped DAO, with the organizational structure with a corporation,
Mm.
which creates and limits the liability of members. and it is much more favorable for those members. But anyway, the entity-less DAOs still exist, and even though the members they have the full liability, it can be favorable for such DAOs that don't have the main intent to maximize profits, but more like it is a protocol DAO, like a type of DAO, or some non-profit DAOs. It can actually choose choose an entity-less DAO because it is much easier to realize almost the full potential of such organizations as being a general partnership, because it is not restricted by all the requirements that are required from corporations.
Talking about privacy, is privacy a concern in DAO? The data privacy?
Yes, of course, because first of all, DAO they are targeting a very big amount of different natural persons who actually resides in different countries. So it is, if you are talking about DAOs, most likely we are talking about cross-border transactions. And in such case, different laws apply. So, as I said, SEC, they think that they have extraterritorial powers. So they, even though the company is incorporated in other country, they think that they have authority over such country. With data privacy laws, extraterritorial laws, extraterritorial principle applies as well. And now we have all the countries which thinks that they have authority over such DAO. For example, if you are talking about GDPR, if you are obtaining any privacy data of European residents, such countries, such members, they have authority over such legal entity, notwithstanding where it is incorporated. For example, in Cayman Islands, still they can find the Cayman Islands corporation. And furthermore, it is a problem with blockchain, since the private data, the data that is written to such blockchain, it doesn't give the full anonymity of such data subjects, which have given you such data. It is more like pseudonymization, because anyway, it can be, the data that is written to the blockchain, it can lead to that individual. Furthermore, it is the case with wallet, since by one transaction you can find the wallet, and so with that you can see all the transactions, which can actually be a problem with identifying such individual. So you shall remember that mostly all of the privacy protection laws are extraterritorial, and you shall grant all the rights that are foreseen in those laws. Here we have two main laws. It is Californian CCPA and European GDPR, because they are the strictest one. And we have another problem actually here with erasure right, since all the data subjects, they have rights, so their data is erased, but it actually conflicts with the immutability of blockchain. You cannot just take and delete all the data from the blockchain. It conflicts with the main principle of immutability of data.
Correct.
Yes, there are some resolutions to it. For example, creating the separate database for such another blockchain where you will keep those data, private data. I don't remember any examples who successfully realized it, but it is the way. And also, since you shall erase the data because it is provided by GDPR, many companies, they use multi-signature accreditation to do so. So yeah, you erase something from the blockchain. Immutability isn't followed. The principle uh, uh, is violated by,
Mhm.
but anyway, there are a very high standard for erasing or changing something on blockchain.
And that deals a lot of electricity and power if you're gonna try to erase the blockchain, a part of it in the blockchain. For me, it's next to impossible given the fact that it should have that immutable component. Um, I oh, I got my little boy here. Oh, saying good morning. uh, I just lost my train of thought. Okay, I got it. Going back to the regulators, I'm gonna ask something after this, but it's more of the regulators. How mature are the regulators in their understanding of DAO compared to the different private entities? Because it seems to be, maybe I could ask that in Europe, how are they mature in their understanding, even in blockchain? Are they at par with the different private entities who are really endorsing blockchain technology, more so DAO?
Actually, if you are talking about Web3 in general, yeah, so most regulators they don't distinct Web3 from DAOs or any other uh, we may say features maybe of Web3 because if we are talking about sandboxes, there is distributed ledger sandbox in European Union. It is a regional sandbox, and any startup they can try to launch their startup just to
Mhm.
try, without licenses, with lesser requirements to kickstart their business. And in that case, yeah, they understand. So regulators understand that it is hard, it is complicated to follow all the laws because they are very burdensome in some cases. And so to kickstart some startup, there are initial capital, for example, requirements that can reach $1 million, $5 million, and no one can start a business in there. But with such sandboxes, firstly, the licensing requirements is disregarded, and other strict requirements are disregarded. So for DAO, for example, distributed ledger sandbox is a way to just launch and try something. But talking about other perspectives, uh, there are not much countries that actually recognize a DAO as some separate uh, company, legal structure, or anything like that. Moreover, it is very hard for them to accommodate to blockchain. Most of yeah, here we have another problem with digitalization because most of reports uh, I can't give you a specific example, but sometimes reports they shall be submitted in writings, not
Mhm.
electronically or something like that. But DAO, it is all the DAO is about digitalization,
Mhm.
and yeah, it is. We have such a problem. I can't even give you example in Europe that have successfully used the DAO precedent and have created a dedicated laws for such companies that startups would use. Um, there are some movements actually made. For example, in 2023, German has presented the draft e-shares for e-shares. So it is actually possible to create some DAO that will be just a general corporation, but tokens will actually represent the e-shares in the company. So yeah, members will be able to vote, members will be able to get dividends, and etc. etc. So yeah, there are some movements, but at the same time, now we don't have some dedicated frameworks for DAOs in Europe.
This segment is brought to you again by ICORBP, or International Council of Registered Blockchain Professionals, together with our guest Icon partners. We talked about privacy. Maybe we could move on intellectual property rights, IP, in a decentralized environment. Now, protecting the IP in a DAO can be challenging, or is it challenging due to the open and decentralized nature of these organizations? Effective IP management strategies are necessary to safeguard innovations. In a decentralized environment like DAO, how can IP rights be protected and managed effectively, and legal considerations that are essential for ensuring that the proper IP governance.
Yeah, so we have here again some problems since the companies, the DAOs that want to go with entity-less uh, organization, they will face such problems since it is very hard to understand to whom belongs the intellectual property. And since the idea of decentralized autonomous organization is that all the members contribute their works or anything else to the DAO, uh, it will be very hard to prove that DAO has something because there is no entity actually, and the creator of intellectual property shall be the author of intellectual property. But actually, there are some movements. For example, in the United States, there is a law, Lanham Act, and it is said that actually some DAOs they can go with unincorporated association. Don't remember the test that shall be applied to them, but such companies, unincorporated associations, they can be protected by that Lanham Act. But
Mm.
with general partnerships, it is much more complicated how everything shall work because in general, the partners shall be authors of those intellectual property created with the measure of who contributed the most to such intellectual property or to such object of intellectual property, which shall be proved by those partners themselves. So, yeah, if your DAO actually has too much intellectual property, it has some trademarks, patents, and etc. Most likely you shall go with the company, or at least you shall structure your company that way that, for example, you may have the DAO entityless, but you may have also the corporation that shall hold all the intellectual property
Mm.
with on behalf of DAO, for example. Yeah, here we can use different structures with trust, utilization, and etc. But for general partnerships, it is much harder to do so. Um, so most likely, my advice would be for those to go and incorporate companies for DAOs in those jurisdictions before mentioned, like Wyoming, for example, Marshall Islands, even Cayman Islands, Switzerland, and etc. So uh, at least the intellectual property created by members uh, it will be owned by the DAO itself. And in case, for example, some member leaves the DAO, he sells the token, he will not have any claims to those intellectual properties that, for example, he created. So how actually the intellectual property can be transferred in organizations, for example, of course, by using smart contracts.
Mm.
They can be structured like that, that by transferring some intellectual property or contributing to DAO, the license agreement is signed and intellectual property is given to DAO.
Mm. Let's go to the dispute resolution, and traditional legal process may not suit the unique needs of DAO, and leading to the exploration of alternative dispute resolution methods that can be integrated to DAO governance frameworks. And as traditional legal processes may not align with the decentralized nature of DAO, as we have been talking for the past few minutes, what alternative disputes? Are there alternative dispute resolution methods that you see emerging, and how can they be effectively integrated into the DAO governance?
Yeah, so talking from the legal point of view, the right to uh, be protected in courts and etc. It is absolute, of course, and even if it is entityless, anyway, the general partnership can be sued, and etc. Yeah, it is understandable. But if we are talking about alternative dispute resolutions or any other ways how members of DAO can resolve their disputes, we can actually go through different ways here. Since there are some DAOs that firstly was created as DAO, and then they have created the decentralized court. Actually, if I'm not mistaken, the name of that is Kleros. So yeah, it works like by smart contracts you can apply for their proceeding, where they will with a dedicated and trustworthy so-called judges,
Mm,
they will resolve your dispute. And with smart contracts, such a decision, it will be executed, and it will be enforced. Not as we understand in general definition of the final decision made by general courts, but with smart contracts, if we are talking about idealistic DAOs, and if no one objects it, it can be done such a way. Of course, another ways that can be the dispute resolution can be structured, that there it is the usage of there are actually, I don't remember the example, but there are actually uh, decentralized arbitration. Maybe there are no not much distinctions between the decentralized court and decentralized arbitration, but yeah, it is named differently, but the idea is the same. It is, of course, mediation, decentralized mediation. For example, it can be made with a mediator who is a third party, just a general mediator, or it can be made with even like a decentralized
mm,
mediator that is chosen by voting of every member, and it is a trustworthy mediator who will judge who is correct, who is incorrect in such a situation, and will lead parties, members, to reach an agreement on the dispute, on the subject of dispute. And also, there can be some mechanisms with smart contracts. So there will be
yes.
written the rules. If something um, if something emerges in the external world, then it will be automatically uh, executed. And here we may use oracles, which will take some information from external world, and in case that the conditions they are met, it will automatically execute that contract.
Mm,
So yes, we can use here different approaches, and we can use general court, as I said, even though, for example, it is entityless general partners, they may sue or be sued, and etc. But there are much more interesting alternatives, decentralized alternatives that I have mentioned to use by decentralized autonomous organization.
yeah. I was more inclined of going to having those disputes agreements within a smart contract in the DAO. rather having the traditional arbitration. You did mention we
Yeah,
talk
yeah.
about cross borders, and wherein we go from one country to another, and there's a lot of cross border DAO activity. You did mention that, and one thing that came back to me are it's a complex legal challenge. Who will regulate who? If these things are all over the globe, is there a one centralized uh, global DAO operations who would regulate this? And these activities, they frequently engage in um, different countries, which raises a significant, again, legal challenge. What are the key challenges that you personally see in this area, and how can they be mitigated, or can it be mitigated?
Yeah, so talking about cross-border transactions and cross-border operations of DAO, there are too many actually concerns and considerations that founders shall consider. And first of all, is that DAO isn't broadly recognized. Don't know how to even say it. A substance or some entity, because most of countries they don't understand what it is, and moreover, we have conflicts with an existing laws here. Since if you are holding the cross-border transaction with the counterparty from another country, most of those counterparties they may be subject to um, counter-terrorism laws or money laundering laws, anti-money laundering laws, which requires from those counterparties to conduct the due diligence procedure to actually find out who ultimate beneficial owners are, and etc. etc. But in the idealistic decentralized autonomous organization, there are no ultimate beneficial owners. There are ideally there are no controlling natural persons who have uh, the
Mm,
25% of share in company, as it is required by such anti-money laundering laws.
mm,
But such counterparties they shall find out who those ultimate beneficial owners are and who those controlling persons are, and how you can tell them. You will be telling them that you are DAO and you shall not go through all those procedures. But there is no such law that absolves DAOs from undergoing those procedures.
mm,
So it will be very hard for those countries, for those DAOs to have their cross-border transactions executed. Moreover, there are some tax considerations actually, because generally members, if we are targeting different countries, members they shall show, for example, that they are getting some dividends from some company, if you are talking about for-profit DAOs, and those dividends they shall be taxed in such company, for example, with control of foreign corporations. Many countries have such laws, and there is some questions with that. If you are talking, moreover, if you are talking about entityless companies, also there are, as we were we were talking about data privacy. As I said,
mm,
it is extraterritorial laws that every country has an authority over such DAOs, and conflict of laws, because many laws of different countries they are in conflict with each other, and not much many countries actually recognize the DAO. And also with cross-border uh, target of decentralized autonomous organizations, here we may see the soliciting of those residents of such countries, because if you are trying to target the residents of United States, most likely SEC will think that they have authority over you. If you are trying to target European residents, of course, the regulators of those countries, for example, BaFin in Germany, will have authority over such company. And moreover, even with offer of token under MiCA regulation,
Mm.
most of companies they shall have a representative in such a country. Yeah, it depends on the type of tokens, but most likely it would be advisable for such companies to have the company in such in European region. And moreover, with entity-less company, uh, the offer of tokens, it shall be a legal entity. So here we have another problems. So yeah, we have problems with cross-border transactions on different levels. Either these are counterparties relationships, or even on the level of just offering your token and trying to get new investors.
We talked about
Moreover, with
privacy.
investors,
Yeah, go ahead.
yeah,
Go ahead.
yeah, with investors, every country has their own laws on investors. So
Mm.
there are thresholds which you cannot exceed for unqualified investors. So you
Mm.
shall remember, if you, for example, exceed those 100 unqualified investors threshold, you shall register your token, for example, with security regulators, or undergo any other procedures that is required by those countries.
You already answered my next question, which is safeguarding the DAO investors, and how can this be done? Because we look at the clients now on their side. We talked about the regulators a while ago. Now it's the DAO investors. How can they be safeguarded, given that they have a delicate task and these legal measures are needed to ensure that the interests of the investors are pretty much safeguarded without one thing, stifling the growth of DAO. Because once there's too much regulations, it stifles the advocacy, it stifles the growth. And maybe you could expound more about measures in safeguarding and implementing this interest of your investors while still fostering innovation. Now we're talking about fostering innovation and not stifling what DAO is within the DAO ecosystem.
Yeah, so most likely for protecting the investors, we can actually distinguish here the investors that will be viewed as members of such a DAO, because yeah, they can invest their funds but not get any token, for example. It depends on how they structure such investment. And those who just, so the first category is the one who just invest funds because they believe in the project, that it will grow and bring some investment returns. Yeah, it can be structured with different mechanisms. But another type of investors is those who, for example, buy many tokens of
Mm.
such DAO, and then they think that it will grow in price, or it will bring them dividends, and etc. So depending on such, there shall be different mechanisms how such investors shall be protected. So first of all, notwithstanding which type we are talking about, of course there shall be an agreement between investor and DAO. Ideally, it shall be done with smart contracts,
Yes.
but each jurisdiction has its own understanding of smart contracts, because not all the jurisdictions they actually recognize smart contract as a general normal contract.
Mm.
And before that, you shall understand what is the understanding of such a jurisdiction towards a smart contract. Uh, So if it doesn't recognize smart contracts, then it shall be just a general investment agreement, for example, or anything like that. Uh, yeah, it depends on how you structure such company, but it would be ideal if investors they had some approval mechanisms for a very essential and major decisions. It would be idealistical, but not for. But it is maybe not feasible for decentralized autonomous organizations,
Mhm.
since every token shall give the voting right, and every token holder uh, they have the one vote, and yeah, it would be even more ideal if uh, one token holder had only one vote, notwithstanding how many tokens he actually have. Because in that case, the holding the very big amount of tokens, in case if the one token gives one voting right, it will lead to centralization actually, because whales can accumulate too many tokens by themselves and then have the prevailing right to vote.
Correct.
So yeah, ideally, the one member shall have one vote right. Moreover, with investors who have invested and are members of DAOs, of course, they shall have a right to vote. And I don't know, yeah, it everything circulates around the possibility to approve some decisions, some major decisions, and maybe for them their token shall be viewed as trustworthy. For example, they may be appointed as mediators in such DAO, for example, or they shall have some judgment rights, for example, in case of dispute arising, and etc. So it will somehow, first of all, give them some more power to um, maybe control some disputes, because no one shall
Mm.
control the DAO because it is decentralized. And maybe in such dispute resolution, there is a key to solution to incentivize, for example, firstly, investors to invest in such company, and then protect them from protect their interest, because
Mm.
they will not give a judgment that conflicts with the DAO's interests.
I was looking at the smart contracts and that would develop between the investor and the company itself. And the question is, are the smart contracts legally binding? And it depends on different countries. And usually, there should, if you say it's legally binding, there should be a involvement of the regulators themselves. Anyway, we did pass through the 1 hour mark. Do you believe that? Time is so fast.
I have
And
noticed it.
my last question would be, what is the future role of DAO? How do you see DAO in the next 5 years? And especially with this December 2024, MICA is coming, and these regulators would stop. It's becoming a reality in EU. Plus, I guess this is also important, the incoming so-called bull run, where you have the smart money coming in, and the implications of the political nature here in the States, wherein if this party wins, there's a big support in cryptocurrency and blockchain. This party wins, we'll have a hard time, whichever, in the Bitcoin space. So, what's the future role of DAO, considering
I think,
all of those aspects? How do you see it?
yeah, I believe that with DAOs, there is a future actually. Moreover, I'm writing the research on DAOs, and given our regulators uh, before war, of course, advertisements that they want to create the Ukraine as something very innovative for startups and very favorable for them. I believe that DAO can emerge here. Firstly, with my research, of course, that I will provide how to structure everything, how to create and to make those DAOs really decentralized. I hope so. But for DAO, we may see different examples where society just unites to reach some common goals. So with that, that every person that is in such a decentralized autonomous organization have a voting right, have a right to determine the destination of such a company, the direction of its development. It is very valuable and wasn't reached before with general corporations. Since in general corporations we have major shareholders, minor shareholders that can't vote on anything and can't define the direction of companies. But with DAOs, we really can reach some social goals and really can make the minor shareholders, which would be in general corporations, matter. And I believe that, for example, with non-profit goals, it can change how we understand non-profit organizations entirely. Because I believe that with non-profit organizations, for example, it is the best type that can enjoy those features of decentralized autonomous organization. And we can see from the trend, actually, yeah, it is very slow, but many jurisdictions, they are trying to accommodate to DAOs. They are creating their legal frameworks, or at least regulators, they issue recommendations, and they are just recognizing the DAO, that it can be created and general structures can be used. Moreover, with digitalization, I think it will facilitate entirely the organization and operation of DAOs. So yeah, I think that DAO will not end in the future and will only develop itself, and many jurisdictions will just accommodate to those practice.
How is Zelensky with cryptocurrency?
Actually, we have the Minister of Innovations and Integrations, and it is federal, and he choose the direction where it goes. With war, it has ceased. Actually, we don't have law on virtual currencies
Mm,
still, and it is better for us because anyway, I think we will implement the MiCA regulation.
mm.
And in general, our country it strives to build a very web-free, favorable country.
Final thoughts. I'll give you the full frame. Anything that you want to say, if you want to give a shout out, go ahead. Please do.
Uh, I'm very glad for this opportunity to share with my insights, with my opinions, how I see a decentralized autonomous organization. Of course, shout outs to my company, Icon Partners, the best web-free legal company. And of course, shout out to my university. It is National Law University Yaroslav Mudry, which gave me such knowledges that I can apply and actually can be part of very swiftly emerging and changing Web3 world. Because, yeah, I believe that I am a part of those Web3 projects which we help to structure and actually launch themselves.
Thank you so much. I'm going to say this, correct me if I'm wrong. Thank you, Professor Vladislav Odiensky. Did I pronounce it right?
Yeah.
There you go. Thank you. And it's a pleasure having you here. And it's a good talk. All things like link on the description box. I will add it how you could reach out, how people could reach to Icon partners, and at the same time, how they could look up for Vladislav on his LinkedIn profile. Would that be okay? I'll add
Yep,
your
yep.
LinkedIn profile in the description box. And that's it for now for the block brought to you by ICORBP, or International Council of Registered Blockchain Professionals. Don't go yet, Vlad, because I'll just put this outro and then I'll be coming back anyway.